programa es una producción independiente. Las opiniones, comentarios y expresiones del mismo no representan necesariamente las políticas institucionales de Doral Voice ni de sus patrocinadores.
Good afternoon, friends. Ruben Alcoba, I'm here at Doral Voice. Thanks to the family Esquivel, to Doral Voice. We're going to be today doing a presentation on what a music copyright is and how to protect it, and pretty much the definitions, because a lot of times you get to, okay, I got a copyright, but you really don't know what a copyright is, when it gets protected. Sometimes you end up giving away your materials not knowing that you think, oh, I performed a copyright. I'm the first one who performed it. I own this copyright. That's not so. And we'll go slide by slide through this presentation so you can see when you own it, the protection begins, why should you register a copyright federally, is it needed to register a copyright federally to have a copyright? Questions like this are going to be answered. Also, there's two types of works that receive copyrights in the music industry, and it has separate rights that go with them. We're going to discuss that issue too. Besides the copyrights, as you know, we do trademarks, and musicians should always get trademarks. Musicians, unless they're making inventions on new instruments, they're really not going to be filing patents. Although I do have a musician who has filed patents on accessories that go with musical devices, but usually musicians going to more than likely concentrate on protecting the name he uses as a to perform or to record his scores under a trademark, and he'll protect his musical pieces using copyright law. He'll also protect his sound recording using copyright law. It's important to note that when two people collaborate on any type of musical piece or recording, the people there's going to be rights that go along with it, and the people who own those rights are going to own equally all pieces of that right. Unlike with patents, where each one could sell the rights to the invention, and a copyright, if they would license, sell, lease the copyright, they would have to share equally with the royalties, or however they have sold the rights or benefited from the rights. So let's begin with this thing here. Let me see. As you are well aware, my name is Ruben Alcoba. My practice is over here in Miami, Florida. Actually in Doral, Florida. My website's miamipatents.com, also alcobalaw.com. Our number is 305-362-8118, 305-362-8118. Please call us if you have any questions regards to this presentation or any aspect of patent, trademark, or copyright law. All right, so let's get down to the meat and bones of this. What's a copyright? A copyright is a form of protection grounded in the U.S. Constitution and granted by law for original works of authorship fixed in a tangible medium of expression. So a copyright covers published works and unpublished works. What does that mean? Well, we're going to get to it, but the main thing here is that because copyright law is in the U.S. Constitution, that makes copyright law, believe it or not, no one can bankrupt you on it. If someone infringes on your lawsuit, on your music or your score or your recordings, you could sue them. And normally people say, "Well, my client's has no more money; they're going to go bankrupt." No, that's not the case. Bankruptcy law does not trump copyright law. The copyright, your claim or infringement against a person stealing your musical score or your sound recording, that would go right through bankruptcy court, and you would be able to collect on your materials. So don't let someone con you into believing that if they file bankruptcy, you're not going to be able to collect on whatever you recorded. That's actually not true. Copyright law, bankruptcy law, they're two laws that are both protected by the U.S. Constitution. So let's get to the next slide. A work is an original work. What's a work is an original work? Okay, a work is original when it's independently created by a human author. So in other words, a human has to create the work, and when it has a minimal degree of creativity. What's a minimal degree of creativity? It means it has to have a spark of creativity. It requires a minimum amount of creativity to have an original work. Next slide, please. What is a published work? Okay, so remember that you have what's called published and unpublished works. An unpublished work means when you do nothing. In other words, you perform the work. Uh, an unpublished work, you don't you don't. Well, we're gonna cover this real quick because it's the best way for me is to describe it exactly the way it's defined. A work is published when a copy of the work is distributed to the public. So you have to distribute the work to the public by sale or other transfer of ownership, or by rental, lease, or lending. So it's key, in other words, to distribute your work to the public by sale, other transfer of ownership, by rental, lease, or lending, or offering to distribute the copies of foreign records to a group of people for purposes of further distribution, public performance, or publicly display also constitutes publication. So that's a published work. I have to distribute the work to the public, and that would be considered published work. Published work would mean I have not published the work. Simple enough. So what rights does a copyright give you? A copyright gives the owner the right to prepare derivative works based on the work. 2, to distribute copies of the foreign records or the work to the public. To perform the work publicly if it is a literary, musical, dramatic, or choreographic work. In this case, it would be musical. To display the work publicly if it is a musical work. We're going to talk about musical here, but it's also literally, dramatic, or choreographic. And lastly, to perform the work publicly by means of a digital audio transmission. And that's what we're going to do because we're talking about sound recordings. Okay, what can be copyrighted? Well, we're gonna do. There's 8 things that can be copyrighted, but our main goal is going to be the sound recordings. The first thing is literary works, musical works, including any accompanying words. That's one of the ones that has to do with us. Dramatic works, including any accompanying music. Pantomimes and choreographic works. Pictorial, graphic, and sculptural works. Motion pictures and other audiovisual works. Sound recordings, which are works that result from fixation of a series of musical, spoken, or other words, and architectural works. In this presentation, we talk about musical works, and of course, sound recordings. But it's also important to note that if you have musical works or a score that you put in a motion picture, that's not correct. That's not considered a musical work. That's considered part of the motion picture, which is interesting. But just a little side note there. Okay, what is not protected by a copyright? A copyright does not protect 1. Ideas, procedures, methods, systems, process, concepts, principles, or discoveries, because that's protected by a patent. Works that are not fixed in a tangible form, such as choreographic work that has not been notated or recorded, or an improvisational speech that has not been written down. In other words, you have to put it in a tangible form, and we're going to discuss what that means in a few minutes. Titles, names, short phrases, and slogans. A lot of times people want to get copyrights on slogans and short phrases, and you just can't do it. Why? Because this is the way the law is. Familiar symbols or designs can't be copyrighted. For example, you're not going to be able to get copyright on a money sign, a dollar sign, or you won't be able to get a copyright on some religious symbols because they're open to the public. I had someone try to file a copyright. I think it was like for the saints, that like the symbol of the saints or something like that. They were definitely denied a copyright based on that. 5, mere variations of a typographic ornamentation, lettering, or coloring. And mere listing of ingredients or contents. In other words, I have ingredients and I really don't put any effort into it. I just put here's the ingredients. I don't put any order to them. I'm not going to get a copyright. But now, if I put an instruction of how to put these ingredients together, I would probably get a copyright on a recipe book. Next slide, please. Copyrights for musicians. Okay, now we're going to start our main presentation. This is going to be a very short presentation today, but the main thing is for me to help the public understand how copyright works with the music industry, which is what I wanted to do. But before we got to that, we had to actually define what a copyright is. And I think we have done that, but I may have skipped one thing here. Wow. Okay. So there was one slide here that I didn't catch here, and what's a tangible medium? Okay, and I just realized that slide I don't have with me, because how do you protect this work? What's considered to be protected? And while I was preparing this presentation, somehow that slide got erased but inadvertently. So, in order to be in a tangible medium, the work has to be either on on a sheet of music or in a digital format. Okay, so in other words, I have to be able to show that whatever I'm presenting was recorded there, and it's able to be, in whatever I recorded, is able to be perceived by the public. In other words, it's not just recording the object on the medium itself, but it also has to be perceived by the public. If it can't be perceived by the public, it will not be considered to be a tangible medium. So there's one slide that's missing in this presentation. That was the slide that somehow, I don't know what happened there, but somehow I got erased from my presentation. But it was a very important slide because what it did is it kind of guides you into something uh, that a lot of people don't really quite understand what a tangible medium is. But I think I did a pretty good job explaining it. The work has to be fixed on the tangible medium, which means that it has to be recorded on the tangible medium. And we'll continue now. I think I clarified that little issue there before we got into the musician issue. Okay, so then let me see what happened here. Was not copyright. Your work will be protected from the moment it is fixed in a tangible medium. Your musical work will be protected from the moment you place your work on a sheet of music or a digital file. Once your work is in the digital file, your work is protected via copyright, yet your work does not have a federal registration and its benefits. The copyright gives you the right to make and sell copies of the work, distribute the copies, make derivatives of the work, and to publicly perform the work. Okay, that's pretty much that's the really quickly what it does. Okay, so let's go one by one here. Your work will be protected from the moment that is fixed on the tangible medium. Okay, you already know what that means. It's on a sheet of music or it's in a digital file, and that sheet of music or digital file is able to be seen by others. Okay, in other words, it has to be able to be perceived by other people in order for it to be a copyright. All right. When do you own that copyright? You own that copyright the moment that you put that work on that tangible medium that can be perceived. Okay, now the problem is that if you do nothing to protect that copyright, if you do nothing to record that copyright, if you do nothing to show to conserve the rights of when you first put that copyright in writing uh, anywhere, some unscrupulous person could come by and try to steal your work by claiming that they're the ones who originally came up with the copyright. That's why you would register your copyright federally in order to conserve that. But there's other ways you could send emails and stuff and try to prove it. It would be costly. It would be costly to prove to go to court. You would go to federal court. Before you go to federal court, you would have to have federal registration. Um, and if you don't register the work in a timely manner, you're not going to get statutory fees. You're not going to get attorney's fees. You're going to have to come out of pocket to be able to demand to place someone in court first to prove that you're the owner of that work, because now you have to show, hey, I was the first one to put this in a tangible medium, and that was able to be perceived by the public, right? So that's going to cost you money just to prove. Then after that, you're going to have to show, okay, when you first presented, when that work was actually first presented to the public, right? When it was first published, you want to put that. And then once you have all that, you're going to come against attacks of the other person, more than likely saying, hey, we came up with the work before that. We came back with simultaneously. It's going to be costly discovery issues. A lot of people are not going to have the means of how to protect themselves from that type of theft. And a lot of people have gotten robbed in the music industry because of this, because sometimes, they're great musicians, very, very savvy people, very, very intelligent people in the music industry, but that maybe they're not as savvy in contracts, or they're not as savvy in just in the street, and then you have people who just take advantage of other people's kindness, and that happens often in the music industry. Now, uh, once your work is in a digital file, or it's in a sheet of music, it's protected. Uh, but again, federal registration has a lot of benefits. The rights that it gives you, well, it gives you the right to make and sell copies of your work, to distribute the copies, to make derivatives, like you want to sell, make derivatives of your song, maybe longer compositions, shorter compositions, or maybe put 2 or 3 songs together, then you would have that right, and also obviously the right to perform the work. The next slide is going to be two types of musical work. What are the two types of musical work? All right. Uh, the two types of musical works are a musical work is a song's underlying composition along with any accompanying lyrics. Music works are usually created by a songwriter or a composer. And the second type of work that goes with the music industry is a sound recording. A sound recording is a series of musical, spoken, or other sounds fixed in a recording medium such as a CD or digital file called a phonorecord. Sound recordings are created by the performer and the producer of the recording. Now listen, now the performer is going to have rights that he'll be able to license. The producer will have the same rights. Anybody involved in this sound recording is going to be part of the rights. They're going to have more than likely have rights into this sound recording, and they'll be able to get royalties, benefits from producing that sound recording. While the songwriter, while the composition of the songwriter, more than likely he'll be the only one that has all the rights. Okay, what are musical work rights? The owner of a musical work has the right to make and distribute copies of the musical work, to publicly perform or display the work, and to make derivative works from it, including interpolations, remixes, even videos using the musical work. But remember, they can't be movies because movies get their own copyright. Now, the next thing is anyone else who wants to do these things must either get a license from the copyright owner, use a statutory license, or have an exemption apply, like a fair use. We'll discuss fair use briefly. Fair use allows you not to pay royalties to the owner of a copyright. You have to be very careful how you use it because if you do it wrong, you're going to get sued. So you have to be careful when you use fair use before you try to maybe use notes from a song or lyrics from a song. You definitely want to talk to an attorney. If you have any doubts, always try to always try to get a license from the original author of the work. Don't just trust that because you don't know who came up with the work that the work is not authored. If you see something on YouTube, if you see it anywhere, Instagram, any type of work, any type of catchy noise, sound, recording, whatever it may be, composition, odds are that more likely someone's the owner of that copyrighted track. And if you come across someone who loves to prey on people who may not be as educated or that have the know-how in this industry, you're going to fall a trap to getting sued by someone else. This could happen like with Google commercials, Google AdWords, Instagram AdWords, ads, stuff like that. Your publicist or whoever it is, your marketing guy decides he likes the sound of something. He puts that sound with your promotion of a commercial product or something. Next thing you know, you're getting a cease letter. But forget the cease letter. You're probably getting sued and you're probably getting asked to pay whatever the royalties would normally be for performing that track, that sound on a commercial medium to promote another's product. Now the problem with this is if you have the misfortune of copying the work of someone who's worth a lot, who's made a lot of money in this business, you're going to be paying a very hefty fee. But it could also be someone who's not that famous, but as long as he knew he was smart enough to record his work federally, he'll be able to sue you under statutory damages and probably get at least $1,500 for each time you produce that work, and probably get attorney's fees. So most lawyers will gladly represent that musician, that composer, because they know, hey, at the end of the day, we're going to get paid. You're not going to be able to go bankrupt, and you're done. The problem is if you don't register that work federally within 3 months of your first publication, you lose those rights, and it gets more complex. It also gets costly for you to file lawsuits against people copying work. Okay, a statutory license is created by operation of law, not by contract. With a statutory license, a copywriter cannot say no to use of their work as long as the license complies with applicable legal requirements. I mean, a statutory license would probably be like the radio stations, FM stations, and who could pretty much play your work and sometimes not have to pay the copyright owner's fees for it. Why? Because it's a statutory right. Who knows why they did it? I guess they had a lot of power back then, and they just decided they would rip off the musicians and the composers. That's the only reason I think that someone would get a statutory right to use that. Let's go next. And what is fair use? Okay, that's what we talked about. Fair use is any copying of a copyrighted material done for a limited and transformative purpose, such as to comment upon, criticize, parody a copyrighted work. Okay, so they can comment upon it. It would be like me talking about putting a small clip of music here in this program and making a comment about the music that was being played, or to criticize it, or maybe even to make a parody, like make a funny skit out of the same music. But I would have to change the work. I would have to transform the music, and there's a lot of case law on that. You have to, if you want to do a parody, or if you want to more likely parody. If you want to parody out of someone's music, you really ought to talk to an attorney before doing it. That way you don't cross the line and somehow end up getting sued. So the uses can be done without permission from the copyright owner, but that doesn't mean the copyright owner is not going to sue you. The copyright owner can still sue you and try to prove his case that, hey, you really didn't do a parody, or you used very little parody, and you didn't really transform the work sufficiently to be considered a parody. So you have to be careful about that. And again, a fair use is a defense to a copyright infringement claim. Okay, so remember we spoke about the two types of works that are conducted to the music industry. One's a musical work and one's a sound recording, right? So we already spoke about what the musical work was. Now we're going to talk about what the rights of a sound recording rights are. The copyright owner of a sound recording has the right to make and distribute copies of the work and to make derivative works from it, including remixes, videos using the sound recording. So another person, the owner of the person who would have the right to do remixes and videos would be the owner of the sound recording. That's who would be able to do it. The public performance right for sound recordings, however, is limited to digital audio transmission. In other words, a sound recording doesn't give you the right to make public performances. In other words, the person who would have that right to a public performance would be the author of the work, the one who wrote the score, wrote the music. He would have that right to have someone reproduce that to reproduce that music. He would be the owner of the work, not the person who performed the work. But that's not, a digital transmission would be different. In other words, I record the stuff, I have a digital transmission, I have the right, I have control of when that thing is reproduced on YouTube, whatever medium it might be. This means that radio stations do not have to get permission or pay royalties to publicly perform sound recordings. Wow. Anyone else who wants to use a sound recording must either get a license from the copyright owner, use a statutory license, or have an exemption apply, like fair use. Unlike musical works, owners of sound recordings do not have a public display right. That's correct. Because the public display right would own to the person who owns the musical recording. He has the right to license who gets to publicly play his music. Okay. Now, why would someone federally register a copyright? Well, you register a copyright to establish a claim to the copyright with the Copyright Office. In other words, I'm not going to have to worry about someone saying, hey, I came up with this work prior to you, because the moment I put it in the Copyright Office's hands, from that moment on, I'm deemed to be the owner of that copyright. If somehow I was an unscrupulous person who registered that copyright, then the person that I stole the copyright from would have to sue me in court and somehow show that he had published that work before I registered that work, right? In that way, he could maybe cancel my copyright registration and sue me, right? Because he would be able to sue me, but he wouldn't be able to get statutory damages or attorney's fees. He might be able to get other damages, like maybe an unfair trade practice, but that's not even true. He would just he would be able to sue me for what would be uh, once he proves his case, he would be able to sue me for what he would be able to sell or license that product for, but he wouldn't get statutory damages. So if he's someone who's not famous, he wouldn't get paid much for every time I played his music. Maybe not. Maybe he would. And he definitely wouldn't get attorney's fees. And if I'm going up against if I'm the person who I got the music score stolen from, and I'm going up against Sony or BMI or some of these great things, I don't have the money to fight these people. Odds are I'm not even my lawyer's gonna kick me out the door the first discovery comes in, unless this song becomes like a number one hit and he's got so much proof that he came up with the recording. Maybe that way he would get he would be able to pay his attorney's fees and get some compensation. Uh, Maybe the thief would have done things so egregious that they wouldn't want that to come out in public, so they might come up with a settlement behind the scenes, stuff like that. But you would want to register your copyright in order to conserve your right of or claim of ownership of that music, and try to avoid these issues. Who can file a copyright? Well, an application for a copyright can be filed by the author or owner of an exclusive right in a work, the owner of all exclusive rights, or an agent on behalf of the author or the owner. That's who file. But remember, the owner of the copyright is the author. That's who could file for one. An application to register copyright contains three essential elements: an application, a fee, and and of course you have to deposit the work. Once you deposit that work, you're not going to get that work back. But that really doesn't today. That doesn't really come in effect. But before you used to be able to file like CDs, digital paper, books, stuff like that. But now you do everything digitally. You just upload your digital file onto the internet. So that doesn't really come into effect. So let's see. The next file is going to be, what are the benefits of registering a copyright? Now, this is really important, and this is why a copyright registration, if you were to hire an attorney, would probably charge you anywhere between $500 $750 per each registration. The government's going to charge you about $65 to accept the application. It's just a very it's not a very expensive uh, law to protect. I mean, it's not a very expensive right to protect. The attorneys really don't charge too much to protect it. You could also do it on your own. But the benefits that registering a copyright are definitely worth the investment. And here are the statutory advantages to registering your work in the United States. Before an infringement lawsuit can be filed in court, registration is necessary of a U.S. work. Registration establishes prima facie evidence. Prima facie means that it shows it's like it is the fact, this is the true evidence of the validity of the copyright and facts stated in the certificate when the registration is made before or within 5 years of publication. When registration is made prior to infringement or within 3 months after publication of work, a copyright owner is eligible for statutory damages. Remember, that's what I told you. That's what you want because you get that for each use of that work. Attorney's fees and costs. But when I say you get damages for that use, that means when you benefit somehow from when someone pays for that use. And registration permits a copyright owner to establish a record with the U.S. Customs and Border Protection uh, Office, uh, and that helps you. It helps you stop the importation of copyrighted of works that may belong to you that have been copyrighted. And it stops pirates. Basically, that's what it does. Uh, well, basically that was the whole presentation. I'm sorry I took a few seconds there trying to figure out what happened to one of my slides. Um, it just so happened, I guess, when I was preparing this presentation, I erased the slide that had to be what is a tangible medium and how it's recorded. But I think we did a pretty good job explaining that whatever your work is has to be fixed on a tangible medium, which means it has to be either it's just somewhere where your work can be recorded for a small period of time, and and wherever that work is recorded can be perceived by another person. If that's the case, then that's a tangible medium. The definition is kind of like it's not that clear, but the reason, of course, is because now with the digital files, the internet, and stuff like that, before it was easy, a CD, a piece of paper, a piece of wood, whatever, a sculpture could be, in other words. But as progress develops, the, we're now able to present stuff on mediums that didn't exist 100 years ago. So that's pretty much what a tangible medium was. My name's Ruben Alcoba. I I I made this presentation in English because for me this is not the a practice of law that I specialize in. I try to make it as simple as possible, and I think it would have been a little smoother if I hadn't lost that one slide. But I just lost a slide. That's the stuff that happens. I think we were able to cover it. I would have liked to have you have seen the correct wording of the words on the slide because it would have been a little more. It would have been a little more easy to follow. But I think we did a good job explaining it. Again, Ruben Alcoba over here at Doral Voice. Hope that this presentation helps you a little understand what a copyright is and what musicians have to do to protect it, and also what aspects of music can be protected using copyright law. If you want to contact me, 305-362-8118, 305-362-8118, or at Alcoba at alcobalaw.com, Alcoba at alcobalaw.com. We're here in Doral, Florida. And if you have any questions, please contact Doral Voice. Get them your questions. I will try to answer them. If you want me to speak about any type of legal matter that has to do with intellectual property or business immigration, please send them a note. I will try to respond to any questions you have, or maybe even make a presentation on the subject. Again, thanks to the Esquivel family and Doral Voice. Have a great week, and thank you for listening.